Guess we're ready to start. So, if you're building a business, at some point, you will have or should have a conversation with someone about IP, right? And that can be a conversation with a co-founder, that can be a conversation with a funder, that can be a conversation with an engineer, whether working for you or contracted, that can be a conversation with a potential buyer. It can come up in a lot of different ways. And the purpose of this panel is to talk about some of the ways that it can come up so that you'll be prepared to deal with it, right? And the dealing with it will take different forms depending on your business, depending on your industry, maybe depending on your stage of development. But what you don't want to do is not deal with it. So this panel will help you figure out how to deal with it. So I'm going to start by asking each of my panelists to introduce themselves a little bit more in detail, giving a little bit of your background and the relationship of intellectual property to your practice, your work, to sort of set some context for our audience. When we start with Jack. Thanks, Jack. Amy?
Hi, I'm Amy Davino, formerly known as Amy Botwinick. I am a 1991 Pace Law grad, and I've been in the intellectual property world for almost 30 years now. I'm currently with Cozen O'Connor, who has an office here at Three World Trade in New York City. I co-chair their trademark prosecution group. I've been with Cozen for about 14 years now, and my practice spans the globe. I handle domestic and international trademark matters around the world. Everything from transactional matters, licensing, distribution agreements, acquisitions and mergers, trademark protection, enforcement matters, litigation. I practice before the U.S. Patent and Trademark Office down in Alexandria, Virginia, and in federal courts in the U.S., throughout the U.S., and in other government agencies throughout the world. Obviously my practice really is just very diverse. I handle matters involving individuals and global corporations. I am also intimately involved with a lot of startups, early stage companies. Cozen actually has a program called Co-Pilot where we offer or lend services to early stage and startup companies at a reduced rate. As far as the industries are concerned, I'm involved in everything from pharmaceutical to software to communications, transportation, retail, publications, you name it.
Hi, everyone. My name is John Brown. I teach at Boston, where I'm the director of an Austin clinic. It's called the Food and Farm Business Outfit. So basically, an Austin clinic is an opportunity for students get hands-on experience actually practicing law on behalf of real clients. And get started at all of our clients, small farms, small food businesses, small nonprofits that are in the food and tax space, who are focused on environmental issues, equity issues, food space. And we work with students, and broadly speaking, that's what I call transactional law, meaning for small business lawyers, small nonprofit lawyers, helping clients to form businesses, develop contracts, establish businesses, negotiate contracts, include leases for active land, commercial leases, and sometimes advise in favor of the private business. I don't consider myself to be an expert on IP law, but for practice and practice, the general practitioner of small business corporate law, so we do that's very much with our clients. For our clients that are small farms that sell directly to consumers, usually those issues are not as important. So it's not important to get federal trademark protection. And then we have other clients who might be small alcohol beverage distilleries, other small packaged manufactured goods, in which case, and that actually can be important. So we utilize those.
So John, since you introduced yourself third, I'm going to now take the opportunity to ask a follow-up question, which is not strictly speaking IP, but will sort of flow into the rest of our conversation. From time to time, I'm going to take on the role of an entrepreneur in asking my questions. So I've got a business idea. I want to turn it into a company. What do I do?
Yeah, great question. Of course, depends somewhat on the business, what the goals are for the industry is. The very basic thing that we talk about for most of our clients, probably number one is forming some sort of business entity, LLC, corporation, as a profit. Why? Well, one is liability exposure for clients that we represent, making food or eating food, that would be liability issues. It's a very simple way to insulate our personal liability and we will be kind of environmental. But often it's a lot more than that. It's legal for active grow outlets to track with other parties, with people that need to invest in their business. So that's very good for clients. That's usually one of the first things they're doing. Another very basic set is, I think, again, for liability and insurance, general liability insurance, depending on what industry. And then IP, again, for our clients, comes in sometimes, and sometimes it doesn't. Sometimes it's not a priority for them, but often it's already if their plans to growth and recognition of some of the brand. It really depends on what.
So now that we've used the term IP about 20 or 25 times since the beginning of the panel, let's define it for those in the audience who are not lawyers and are not IP lawyers. So what do we mean by intellectual property? What is it? How do I get it? What does it mean for my company? Anybody?
Four basic there are trading. The most copyrights may be the least to most and trade secrets are immensely important in certain day-to-day of startup company. Every time you sign non-disclosure, every time you tell a potential investor the secrets of your business plan company, you are sharing a trade secret, and it's immensely important on a day-to-day basis to do correctly all the things that you protect that trade secret, whether they be
structure that indicates what it's going to be. So IP is something that we give you a competitive advantage throughout the school and
And if I can just jump in addition to giving you the ability to exclude others, intellectual property is also considered an asset. So as you're building your business, you're starting from the ground up, you're not only looking to exclude others, but you're also building equity in your company. And those assets eventually can become very valuable depending upon how quickly the company grows and depending upon what avenue you pursue, whether you're looking to get into the patent space, the trademark space, the copyright space. Domain names are also a form of intellectual property, which are not as expensive to obtain and quite often can become valuable, again, depending upon the industry that you're in. But in addition to being able to exclude others, you should also be looking at the intellectual property as a way to start building the foundation of your company and building value in it. If you eventually look to, build up the company for the sole purpose of either merging with another company or getting bought out, the intellectual property, in fact, becomes extremely important in that type of transaction, and doing your due diligence from the very beginning, covering, dotting the I's, crossing the T's, making sure that what you do have that's protectable is protected, becomes extremely important to a potential purchaser.
So what if I'm in a business that is not a high-tech business? I'm not in a high-tech industry. All this stuff sounds very techy and very sciencey and complicated. I've got a very basic business that doesn't involve computers, doesn't involve software. Do I need any of this?
You do. Do you have a name?
Yes.
Trademarks are the foundation of businesses. But also, which I'd like to just go back to Jonathan's point earlier about, incorporating, forming your business. One point that a lot of folks overlook, and it's not just with the early stage companies, in fact, very big corporations overlook this. Simply because you're able to form an entity in a particular state, in other words, that the company name is available, okay, for use to operate as a business when you register it with the Secretary of State in the particular state that you're in, does not mean that that name is available to use and register as a brand name or a trademark or service mark. The process is separate and distinct. And it is very important that if you are looking to operate a company and use that company name, though, as your brand name, as your trademark, as your service mark, you do need to clear that separate and apart from whether it's available to register as a company name or entity.
So I'm going to follow up on that because I know that everybody that works with trademarks kind of works with the broader process of developing a brand and works with other professionals. So can you talk a little bit about how the IP lawyer, the trademark lawyer, works with others in order to help the entrepreneur actually develop a strong brand, not just register a trademark?
Having an intellectual property attorney involved with your business is, while I understand it could be costly, it is really invaluable. Having somebody on your side, having someone there who knows your business, understanding what your goals are, they will be able to guide you through not only recognizing what intellectual property you currently have, but what you may have and what steps you need to take in order to protect that property going forward. And then staying on track with you to guide you through the different processes that are involved with it, helping you navigate, trying to keep you out of trouble, making sure you're not infringing on somebody else. These are all things that have to be kept in mind. Intellectual property is a very unique area. It's very difficult to navigate at times. It can be tricky. It can become painful. You could be operating under selling a product or service for a year or two, and someone can come knocking on your door and claim that you're infringing them. And you're like, where in the world did they come from? So it's important, as I just mentioned a minute or two ago, from the start, if you have the appropriate clearance searches conducted from the get-go to determine whether that branding is available for use and registration, well, certainly, although it's not an absolute guarantee, because no search can possibly cover every nook and cranny and every potential conflict or risk, but it'll certainly give you a good level of comfort if that brand is cleared from the beginning, and you won't have to be concerned about looking over your shoulder constantly, for years to come.
So now I'm going to switch, and I own a different type of business now. Now I do have a tech company. Do I need patents? When should I start thinking about patents? What does patent pending mean? If somebody comes to me and says they've got a patent pending, do I now have to shut down my business? So now, I'm a coder, but there's a whole bunch of legal stuff that's now in my world, and I need to understand what I need to focus on when it comes to the world of patents or any other IP that applies in the tech world.
And in particular, what it depends on is, I'll say, the type of the technology business that you're operating. If, for example, you're going to put up a dating site and you're going to use a cloud-based solution, and you're going to use a stack of off-the-shelf programs and do it, and you're going to create value in your company by your use metrics and the network effects having lots of people in the company, then the likelihood that you're going to have strong patentable inventions that you want to early on invest a lot of money in, it's not that it isn't something you ought to consider, but as I said, patents are very powerful. But for a true startup, again, in that kind of media off-the-shelf technology world, unlikely to be important. On the other hand, if you are hiring computer scientists to generate new programming techniques, new algorithms, new ways of analyzing or concatenating data, then you very well may have the likelihood that they're going to stumble upon some actual inventions, and most importantly, that those inventions will give you a competitive advantage and allow you to exclude potential competitors doing the same thing you are. So if it is a business in which you're using technology and actually developing new bits of technology, then this can be very significant. And certainly when you go to investors or when you go to your exit strategy, the existence of those patents can be immensely important in gathering additional funding or making the company work more.
You just introduced an element that I want to follow up on: employees. Now, how does my approach to IP have to adjust to the fact that I'm not doing it all myself or doing it all with a co-founder, but I'm now hiring people to do work, and that could be work around development, and that could be work around development that leads to either patentable material or trade secrets, or I'm going to throw in, for good measure, copyrightable material as well. So how does the presence of employees complicate my IP picture?
That's where the work for hire comes in. I guess that's where you're going.
Bingo.
So it's very important that, as much as I'm sure, when you have a new business, you're very excited about it and you're looking to forge ahead and there are new ideas and, you're working on 10 things at once and not really focusing on the fact that you might be pulling in acquaintances, friends, other people in the trade to come in and help you. You could be hiring folks, but you got to pump the brakes, because you have to remember, again, as much as this is a very exciting time for you, you don't want to be disclosing proprietary information to others without getting their assurances that they are not going to be taking it and running with it or sharing it with others. So that's where something called a work for hire agreement comes into play. And it doesn't have to be a very complicated agreement. It could be just a page or 2 or 3 long. But basically what you want those folks to sign on the dotted line to, assure you that they are going to keep all of the information that they are obtaining while they're working with you and for you to themselves. They're not going to publicize it, post it on social media, which happens quite often, share it with their family, with their friends. You don't want them doing that. This is your baby, and you want them to keep all of this information to themselves. Obviously, they can discuss it with others while they're working for you and with you, and they're allowed to share it with others to the extent that you authorize them to. But you have to be very careful with whom you're sharing your information, under what circumstances, and get those work for hire agreements signed by those who you bring into your inner circle.
I would just add so that saying that there's certain possibilities of that there's something from can be that single pendant for high equity is the agreement. That's what the most important thing.
Anything to add, Jeff?
Well, maybe what Amy said a little bit more explicit. The law in this area is a little diverse in the sense that if I go out and retain a consultant to write some code for me, or to write some script so I can build my stack of applications so I can get the service up, and that person creates even some small amount of programming, some small amount of script, unless I've put in place what he calls the work for hire agreement, unless I've frankly used the magic words that I say, it's time to be, it's time to be the entrepreneur of the company, all the rights, then I may not have this. And when I go to sell my company, I'm fine that I'm not able to transfer to the purchaser the rights to all of this code that makes software for. So, it's a little perverse in the legal rule. It's very protective of the person who's the consultant because they wrote the code. Less but from the point of view of you do need to people with your employees, with your contractor, even with your cloud service provider, and service provider. You need to make sure you get all those good steps down so that when you come to the website, and then you can do the next will be able to look at so what you've done
Okay, that all sounds good. I'm now a little bit more clear on things I should be doing, but I got to tell you, it sounds expensive. How expensive is it? How do I balance finding money to pursue IP or pursue work for hire agreements? Because I'm going to be paying somebody by the hour probably to do that for me. How do I balance that with the resources I need to put around my core business? And then what resources are there for me out there that I might be able to take advantage of, either along with hiring an attorney, before I hire an attorney, just so I'm spending money as intelligently as possible?
Yeah, so our clinic works with very small businesses, very small nonprofits that all our work is pro bono, so just qualify for services based on the income level of the business owners. By definition, they're citizens that can't afford to pay a lot of these services. One thing I think that you start with is the difference between executing a trademark strategy or Yeah, he's going to be the strategy itself. And so I'm trying to do reports that here's what I'm the trademark these things. And one maybe this is the name of the company, and then a few others are product lines that I'm maybe starting or maybe I'm thinking about starting in the future. And one is this slogan I just came up with this week, but I think it'd be great to use the slogan when I market that product. And we got to step back. Like when you actually planning to accomplish I trademark this thing. They might not even, they might just trademarks, that's a thing to check out list. Anything I can think of, I can trademark that. And so we talk about strategy and what you may get out of trademarking brand name and what you may not get out of that. What you're actually protecting against, whether that's something that's valuable to that against. Also, Amy mentioned before that you can't necessarily trademark anything. So you should be looking when you're developing brand names, you should be thinking about what actually is trademarkable. Part of that is a question of the confidence concept that happens for him, but we have other things that just aren't trademarkable. The opposite. We're doing one of our products to they often have products that are really descriptive name, it's I don't know what the product is, it's purple guarantee, something like that. And that after describing what the product you probably can't get ownership rights to that because someone else wants to make their own purple guarantee. They should be able to do that. So it's not trademarkable because it's descriptive out of the simple. So I guess it's a long way of saying I think the first thing to do is talk about strategy rather than simply how much of the product people get just about doing that. How do you get some of the strategy? I think that's a challenge as well. I think that relying on the resources that are in network, great purpose here, lawyers may know. We've high level of that strategy before actually getting to the full executing and submitting the application. And there are some resources that are out there for small businesses, entrepreneurs that qualify, start small, think big, some of them, I guess, in the city. Basically, generally for lawyer grant basically, but the whole range of fees and even some pro bono services out there.
To add to that, if you don't mind, I was also going to mention Start Small, Think Big. Actually, I've performed quite a bit of work for them and their clients over the years. They're a great resource. There's a couple of others in New York City. I think Lawyers Alliance, which is another one. In addition, a lot of the federal government websites now have been improved dramatically to assist, as we say, lay people who are looking to try to register and protect on their own. The Copyright Office has some great informative, what they call sheets to explain the process. The U.S. Patent and Trademark Office now also, they've improved their website over the last couple of years to be more user-friendly. And I'm not suggesting that it's easy or you should always be doing it yourself, but it's definitely, you can gain a tremendous amount of knowledge and at least get started on the process. Registering and protecting domain names are not usually too involved. But even the domain registrars these days, if you give one of them a call, they have folks there who are able to walk you through the process and answer a lot of questions. There are also law firms like Cozen O'Connor that have programs like our co-pilot program, which offer services in across all different industries and fields at reduced rates, at discounted rates. So that's, yet another resource that might be available.
Making sure that people get the things to do, which you may not do. And you may not take a certain bit of to do that. But you put hours on that is $10 on making sure you get your sort of and work for higher agreements in place. And then somewhere quite a bit down the road, I think about again, it's the media space where you're generating a lot of attention. You know, if you're a pharmaceutical company, you spend your first dollar and your millionth dollar on patents, because no one really cares what it's all that matters. Can you sue people from exclude your competitors from making the same profit? But again, assuming that we're talking about implement like what these founders were talking about, you start with like
And I would like to just add to that, unlike copyrights and trademarks, though, in the patent space, though, and I just want to qualify, and I'm with you all the way, but on the patent side, you have to be a little careful because there are time bars with patents. So if you do have an invention that ends up where you disclose it, you publish it, it's out there, you could end up becoming time barred from seeking patent protection for that invention. So sometimes it could be a little bit of a balancing act between being concerned about whether it's something of value that you should be pursuing to protect under patent versus the cost versus where are you on the timeline of things. So you have to also sort of keep that in mind as well.
All right, now I'm going to give each of you the opportunity to either go positive or go negative. Obviously, protecting all client confidences. Can you share with us either a horror story of how a client managed IP or a triumph of IP strategy gone absolutely right?
I'll try to go positive. We had a client who, I can't say most of the credit for the success, but a client made a packaged product, two products, sold it locally at a very small scale, and I think the search repeatedly sort of trademark and brand name, very good out of the process. A few years later, so we got them and said, hey, good news, we're selling the product in the same name, and you I'll pay you this very, very small amount of money to enter into the term they use together. Co-sharing agreement, we both use this trademark money to piggyback off your registered trademark. And very wisely, the client said, slow down a little bit here, let's talk about this. And actually, over the first several years, we helped them negotiate something where basically the client smartly figured out what they needed and what they didn't need as a trademark. Ended up being a sale. The client sold the trademark to this other business that had really big capital plans, venture capital backing, and also at the same time licensed back use of the trademark in a limited way for what they needed to do. And they ended up making a lot of money. And I think it was that because one, they keep the whole way, but also they were realistic about what they needed. They ended up with what they needed, which was right to do what they wanted to do, small local scale, and down to big data.
Nice. Positive or negative?
I don't know if I can top that. Well, I'll share just a quick story, a positive one more on the enforcement side. A couple of years ago, it's a little bit more than a couple now though, but years ago, I had represented a actually well-known French jewelry company. They were global, and they had run into some problems with a well-known fashion designer here in New York City. It turns out their worlds collided. As you can imagine, clothing and jewelry are related items. They had both been basically selling in the same space, so to speak, here in the US for years. But things had turned very ugly because the fashion designer was now sort of encroaching on our clients' rights because she was going into more accessories and leaning towards costume jewelry. It turned out from a strategic standpoint, we initially started with duking this out in a dispute before the Trademark Trial and Appeal Board of the U.S. Patent and Trademark Office, which is an administrative tribunal. There's no money involved there. It's just simply registration of rights. And that ended up morphing into domain disputes, and that morphed into a federal court action here at the Southern District of New York. The cases went on for almost 20 years with appeals, an appeal from the up to the Second Circuit Court of Appeals. However, we ended up, we were victorious on all fronts. But again, it was a matter of just putting a strategic plan in place, just deciding how we were going to attack this designer's rights. And it was a very, very long road, but needless to say, we came out victorious.
Thank you. Jack?
Tell a story about positive, negative, more sort of existential. So I mentioned I was a Lubin. There came a time when we at Lubin spun off a company that did healthcare transactions, that moved claims from your doctor's office to your insurance. And we went out when we spun off this company to get a new name for it. We went to, there are companies that work nothing but create. So took one big advertising agency, and they gave us, we picked the name of Kennedy. And then we went to a company called the biggest, prestigious company from New York, and said, tell us that it's okay to do that. And they said, yes, it's okay to do that. So then we spin off this company, we get ready to campaign, we're about to go out, we're about to make a profitable, and then company, and we get sued at the last meeting. Someone looking for a temporary restraining order, and stop us using the name, and their name is MD Online. Now, it doesn't look at all the same. When people who did the search on behalf of the law firm check, they have databases that turn up, in that case, literally 1,100 things that they consider that rejected as not infringing. They never turned out something called MD because it seemed too different for the search algorithm they used. So it's amazing in the sense that that's not a situation. It's the way you can so it's not so that after saying too much money, you need that. They could chat people not likely to use it. But the story is, you know, you can do everything.
Stuff happens. Right. I think we have time. All right. Do we have time for questions? One question? Two questions. Two questions. Yes.
So yeah, when you're recruiting the new team members, or you're obviously trying to share your idea with people to gain networking and to do customer discovery and all these different things. Obviously, there's that fear factor of, oh, they're gonna take the idea and run with it, or they're gonna like do this with it, or they're gonna do this. I've heard two conflicting reports, both from legal advisors and business advisors and different people I've met with. Some say that it's very important that you don't like force people to sign an NDA before telling them things, because a lot of times investors would be like, well, I don't want to do that. But then you have to find that balance between like protecting your stuff when you're sharing with people, because you can't keep it a secret either. So how do you find that balance between dealing with the IP factor of sharing things with people, or getting people to join your team and having them like work fairly and everything, but at the same time not imposing on them and forcing them to like, oh, you have to sign this NDA and everything?
Well, I've experienced that from the lawyer side, speaking with a client, and I understand that, and it can be a little bit difficult at times. But truthfully, at the end of the day, what my advice usually is it's really what your comfort level is. If you're not comfortable, you don't want to force people to have to sign an NDA, right? But if they don't want to sign it, again, you have to be comfortable going with it. If you understand the risk that's involved if they're not signing it. Most of my clients end up just sort of making the decision that if the people that they're approaching are not willing to sign the NDA, then they're just not right for them. But again, it's your business, it's your company, and you have to understand the level of risk that you're entering into. So it's really a business decision. Listen, not every decision you're going to make is going to come down to a legal decision, right? So it's really a business decision that you have to make, and it depends upon your comfort level and the level of risk that you're willing to assume.
I would just add to that. A lot will depend, right? Depends on the level of generality of your conversation, right? You can have a very general conversation about your idea that is not going to create much risk for you. But once you start talking about the stuff that you think makes your business viable, makes it distinguishable from whatever else is out there, at that point, if you're talking at that level, anybody who doesn't want to sign an NDA is not somebody that you should be doing business with. That's my 2 cents. Other questions? Yes.
Are only created when the government and your application application. How do you go to you find when you see that you often say it is going to be able to exclude me from this phase. Not that the stuff doesn't do it, but mostly I think lay people over and hours. Not to say that once you invest in the fund, you engage that operating law.
I would have led with puffery and fluff. Says you've applied, it doesn't necessarily mean until the patent office gives you a patent, you don't really have anything. So keep that in mind.
It's a warning notice.
It's a warning notice.
It's putting the public on notice that they consider that to be theirs and theirs exclusively, that they're attempting to exclude others, but have not yet done so. So.
I want to thank my panelists today, and hopefully we've given you some information that will help you as you continue to develop your business ideas.